Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to a lot of people who call us because they believe that they've been the victim of some sort of medical negligence or medical malpractice. They have gone to a doctor or a hospital to have a procedure done. The procedure's been done. They have some sort of result that they don't like. And then a lot of times those people have then visited a second doctor to talk about the problems with the first doctor, and then the second doctor does a great job and fixes them, and basically they have no long-term negative effects. In most cases like that, the people that we talk to are really angry or frustrated with the fact that they had to go through two procedures in the first place. And the reason they're calling us usually is because they want us to help them pursue medical malpractice or medical negligence case against the original doctor. So usually we spend some time discussing the realities of the situation with them, and a lot of times that discussion has a lot more to do with business than it does with the law. So I'm going to have that same discussion with you here on this video. So in every medical negligence or medical malpractice case, really there's two things that have to be proven. First, the injured patient has to prove that the doctor deviated from the standard of care and caused them an injury. And then secondly, they have to prove what their damages are related to that injury. So doctors have lobbied the Florida legislature for many, many years and have been successful in getting the legislature to create a scenario where it's very expensive and time-consuming and complex to pursue a doctor for a medical malpractice claim. In fact, medical malpractice claims are sort of their own beast in the personal injury world, and they're the most expensive and most difficult cases to win. And doctors statistically win the majority of medical malpractice cases. And so one of the protections that doctors have is that the law requires the injured person to go out and find medical experts that will critique or criticize the care and treatment that the original doctor gave to the patient. And so that typically requires a lawyer to get involved, and a lawyer will reach out to doctors and have them review the potential client's medical records and the facts and circumstances of the alleged medical malpractice. And then that doctor, whoever that doctor is, that medical expert, has to swear out an affidavit. So it's a statement under oath that the original doctor deviated from the accepted standard of care. In other words, he didn't practice the way that all the other doctors in the same community practice. And so depending on the facts and circumstances of the case, sometimes it's a very difficult opinion to get, but sometimes it's fairly simple to get, but it's always expensive to get. Doctors don't critique other doctors for free, and typically they charge thousands of dollars to do it, and sometimes up to or more than $10,000 to give us a medical opinion in a medical malpractice case. So there are certain financial realities to any medical malpractice case, and one of those is that they're very expensive. And so even if you have a clear-cut case of medical negligence, or you have clearly a doctor made a mistake in an original procedure, if the patient doesn't have long-term effects, doesn't have a permanent injury, doesn't have something catastrophic at the end of all of their medical odyssey, then it's not uncommon for us and every lawyer that does medical malpractice cases to just decline or turn those cases down. It just doesn't make sense unless the person is significantly injured, and unless we believe that there's going to be a large recovery at the end of the case. It doesn't make financial sense for most lawyers to invest a ton of money in a case that might be a small case. And again, we know that juries tend to side with doctors more often than patients. We know that statistically from jury verdict research. And we know that juries, if a person doesn't have a catastrophic or major problem at the end of their medical odyssey, we know that juries typically feel like they're kind of lucky and don't award people who they consider to be lucky a lot of money. And of course, every medical negligence or medical malpractice case is different. Every set of facts is unique and different in and of itself. So if you have any questions about a potential medical negligence case, or you want to know whether your injuries are significant enough to warrant the investment of time and money into a medical negligence or medical malpractice case, please reach out to us. We love to answer questions. All you have to do is call our office at 407-254-4901. You can text us at 407-644-4444, or you can even reach us through the Facebook Messenger app.